Welcome back to this course on copyright and related rights law. In this week, we are looking to understand the topic of originality, which is a requirement for subsistence of copyright in subject matters. In today's discussion, we are going to look at what is meant by a work in existence, and is it possible for an incomplete expression to be considered as a work? Let us start with a provision in the French IP Code. Provision L111(2), it states, a work shall be deemed to have been created irrespective of any public disclosure by the mere fact of realization of the author's concept, even if incomplete. Let us break this provision down into its individual components. First, we see that this is a deeming provision, meaning that this provision understands that left to itself, incomplete expressions may not be considered as works. The second component says, irrespective of any public disclosure, meaning that a work can exist or a work is created without it being perceived by the public. Publication of the work to the public could be by issuance of physical copies, or it could be by way of communicating the work to the public by way of broadcast, for example. But in any case, what if there is no such publication? According to this provision, it is possible to consider it still as a work that is created. It then says, all that is required is that it is an expression which is a realization of the author's concept. In other words, it is original. It is independent in its creation. What we were understanding as a dimension of originality. And then finally it says, tying up these components, that even if the work is incomplete, if these components are met, then it shall be considered as a work. What do we mean by an incomplete work? Take a look at this image. Firstly, are you able to identify the subject matter? Are you able to subclassify within the subject matter? You must have been able to state that this is an artistic work and also that this is a sculpture. But you would have also noted that it is possible that this particular sculpture is incomplete. There could be other opinions, but because we are talking specifically about completeness and incompleteness, let us consider that this is not a sculpture which is damaged, but rather it is in the process of being created. And therefore, it is incomplete. The question we are looking to answer is, can an incomplete expression be considered as a work? Or in other words, does an incomplete expression lead to the existence of a work? And finally, can an incomplete work be granted copyright? What we understand from the University of London case is that objectively assessed, an expression can be considered as a subject matter. So if an expression is by way of words, then it will be a literary work. If the literary work is original, then it has copyright in it. But does completeness or incompleteness of an expression have anything to do with the consideration of whether the work is actually in existence? And does copyright subsist in such an incomplete expression? Let us consider before the Punjab and Haryana High Court in 2024, T-Series and others versus Dreamline reality movies and others. It was stated in this case by the court, to claim copyright over something, that something has to be an existing work. The person claiming copyright can assert the same only if he or she has already accomplished a work, be it a book or literary work, cinematographic or photographic work, musical work, or any other intellectual work, by incorporating his intelligence and creativity. What the court is referring to is that for copyright to subsist, there must be a work in existence. When is the work in existence? The court seems to be suggesting the work is in existence when the expression is an outcome of the use of intelligence and creativity by the author. The seeming mix here that we understand is between a work existing in terms of the expression and a work existing in terms of the copyright subsisting in it. But at the foundation, no copyright can be granted unless there is an expression. It starts there. The consideration of intelligence and creativity is a second level consideration which applies in terms of originality. Further, the court explains, mere existence of an idea or existence of fact or set of facts per se, and without involvement of talent, intelligence, or effort by a person in converting the same into a work by any means, cannot be stated to be a work as required under the Copyright Act, for which a person can assert his copyright. You can see here, the court is referring to the distinction between idea and expression, wherein the court is saying that underlying facts which are expressed, the facts themselves cannot have any copyright in it. We have discussed this earlier. Say there is no expression, then there is no scope for any question of copyright subsisting in it. say there is an expression, then such an expression must satisfy certain qualitative considerations, such as the expenditure of effort, application of talent, intelligence, etc., in considering whether copyright can subsist in it. Consider this expression, you are loved. Can we say you are loved is a work? What you would note is that an objective assessment tells us that this expression is in fact a work. But you would recall when we discussed a quantum test related to the informative value for which copyright will subsist in the literary work, we had discussed an important case decided by the Indian Supreme Court. Krishika Lulla versus Shyam Vithalrao Devakatta. In this particular case, the question was whether a title such as Desi Boys, can this title be subject to copyright protection in terms of it being a literary work? What we had noted was that the court said that this particular expression was incomplete by itself. In other words, what the court was explaining was that this particular title, which was having a very generic composition, would have to be juxtaposed with other information in order to have some kind of a definiteness. Therefore, you can see a title of a work has been considered to be not fit to be the subject of copyright law. A title by itself is in the nature of a name of a work and is not complete by itself without the work. The Supreme Court had also noted that there is no instance of a title having been held to be the subject of copyright. But this understanding of why an expression which is in the form of a title cannot be considered as a work cannot be extended to expressions which are not complete but have distinctive understanding in terms of its informative value or distinctive understanding in terms of its perception. Can we say that a single brush stroke in a particular color on canvas is incomplete? Let us then understand completeness as a reference to finishing. In other words, we are making a distinction between completeness as a question not of distinctiveness, but rather completeness as a question of finishing the work. If we say this, then we are saying that despite the fact that an expression has achieved a certain amount of distinctiveness, it would have to reach some kind of a finish line in order for copyright to subsist in it. In other words, component parts which could have its own copyright only when merged together and their sum at the point, at the finishing point, would be considered copyrightable. But who decides what the finish line is? Is it the author who decides what the finish line is? Clearly, if the public has no connection to the expression of the work, then it is the author's intention. Can we say that when we consider originality of an expression, we are saying originality of the expression as a whole, or can originality exist in parts? In other words, can we consider completeness as a question of distinctiveness? This might be slightly confusing. Consider this question. Can a work be fragmented? And can these fragments be considered as original or not? In this image, you can see several components that come together to form a whole. In this whole, there might be several components which by themselves aren't copyrighted. They might relate to commonplace items, they might be concerned with public domain items. But it is also possible that certain components can in fact have some distinctive consideration to which originality can apply. Consider the case of a compilation. When we had discussed literary works, we had discussed how collections and compilations of information can be considered a copyrightable expression because of the selection and arrangement. Now, in such cases, would it be right to fragment the work? In a case of a compilation, we have understood that individual portions have their own copyright question. A compilation could be of information which is in public domain, but the selection and arrangement of these public domain elements can be considered copyrighted. But if you were to take fragments from it, it would possibly not be considered copyrighted. Therefore, in cases such as compilations, we can refer to this particular case from the UK. This is Ladbroke Football Limited versus William Hill Football Limited, in which the court had stated one test may be whether the part which he has taken is novel or striking, or is merely a commonplace arrangement of ordinary words or well-known data. So, it may sometimes be a convenient shortcut to ask whether the part taken could by itself be the subject of copyright. The more correct approach is first to determine whether the plaintiff's work as a whole is original and protected by copyright, and then to inquire whether the part taken by the defendant is substantial. You can see that the court is considering a situation where there has been unauthorized copy. What the court is suggesting is that as a first step, we must see whether the copyright as a whole, in terms of the expression, exists, and then see whether the part that has been taken is a substantial part of that whole. But when we say copyright of the whole expression, are we saying copyright of the finished expression? And if we say finished expression, then does that mean unfinished expressions do not have copyright protection? Consider that unlike compilations, we are considering works which are protectable expressions. That is, the information that is compiled, which could otherwise be public domain elements, are not public domain elements. They are outputs of creative effort. What if we are considering such fragments? We should also consider whether a work should be published for copyright to subsist. To this, we understand that a work need not be published. What is the meaning of publication? The ordinary meaning is the preparation and issuing of a book, journal, or piece of music for public sale. We had seen the French IP code in its provision says irrespective of any public disclosure. We can see in the Indian copyright in section 13, which talks about subsistence of copyright. Such copyright subsistence exists in unpublished works as well. And therefore, there need not be any public perception of the work in order for there to be subsistence of copyright in such an expression. Take a look at this question and think for a moment. If my incomplete expression is published without my authorization, could it be a violation of my copyright? You might have arrived at this question, which is, if an incomplete expression has copyright protection, at what point does it gain such protection? We can say a work has two types of existence. One, as a subject matter, such as literary work, and two, as a copyrighted subject matter, as an original literary work. Are you then able to now point out at what point will copyright subsist in your expression? If we look to section 13 of the Indian Copyright Act, it says that copyright can subsist in original literary, dramatic, musical, and artistic works. So, in considering at what point copyright subsists in a work, we must look to find at what point does originality attach to such work. Therefore, if the work is finished or unfinished, if your expression can satisfy originality, then it seems that copyright can subsist in such an expression. But this point of originality, because as we had understood, there is a possibility that this is a subjective consideration. Is there more to originality than just the fact that it should not be copied from someone else? Or in other words, it should be an independent creation. This subjective understanding brought in by various courts, and its application is something that we will look at in the next two sessions. Thank you for joining me. I will see you in the next session.